Hi everybody, welcome back to Questions with Conti. I'm Michele Conti, and just like last week, we're going to answer a few of our clients' most commonly asked questions. Today we're focusing on powers of attorney. Go ahead, Kristen.
I'm married. Am I not automatically my spouse's power of attorney?
One thing you have to know in Pennsylvania, the law is not based on common sense. So everybody over the age of 18 is their own person, and nobody can legally make a decision for them, whether it's parent, child, spouse, sibling, unless they have a power of attorney, which is a legal document appointing somebody to act on your behalf when you're unable to act for yourself. There are two powers of attorney. There's a financial power of attorney as well as a medical power of attorney. So to answer that question, no, you are not automatically your spouse's power of attorney without a document put in place or without the court intervening and appointing you as your spouse's guardian.
Who can serve as a power of attorney? Does it have to be a family member?
Anybody can serve as your power of attorney so long as they have capacity and they're over the age of 18. Again, some people assume it has to be a spouse, it has to be a child, it has to be a parent. That's not the case. Now, traditionally, most people do appoint their spouse or an adult child, or if they don't have kids, maybe a parent as a backup. But it can be anybody, so long as you trust them and they're over 18 and they have capacity. So if you want to appoint Nancy the neighbor in lieu of your husband, you certainly can do so, although that's not typically the fashion that our clients go with that appointment.
Does my financial and healthcare power of attorney have to be the same person?
That's a really good question. The answer is no. They don't have to be. Sometimes clients will change up the order of appointment. Again, most clients, if they're married, appoint their spouse if the spouse has capacity. And then perhaps for financial power of attorney, I appoint Casey because she's much better with organization and numbers than Angie. And then on medical, maybe Angie's a nurse or a doctor or in the medical field. So we'll make Angie first and then Casey is the backup. But again, it doesn't have to be anybody you're related to. It's just somebody who you ultimately trust to serve as your advocate and do the right thing when you're unable to act for yourself.
If I should become incapacitated, what happens if I don't have a power of attorney?
If you don't have a power of attorney in place, the only way somebody can make decisions for you is by obtaining guardianship. And we do that through the local orphans court. We start with a petition and we request that the court review the matter and appoint somebody to act. And we can do it for both medical and financial decisions. We can just do it on a limited basis. But ultimately, we have to go through the guardianship steps. So we petition the court, a doctor will review, and for instance, the most common with our clients is somebody may have dementia. So they'll perform a cognitive test. That doctor will either be deposed, come to court and testify, or fill out an expert report. That is what the judge is going to base the medical testimony on. And then from there, all parties of interest. So somebody who is the next of kin or has an interest in the matter has the ability to come back and contest the appointment and say, no, Kristen's not a great fit, I should do it. And then we have a hearing. Most guardianships are uncontested and we go in, we put our case on to the judge, the doctors testifies, and if the person is over 18, then the court also appoints an attorney to serve as the advocate or the representative of the alleged incapacitated person. So we have the right the family can hire an attorney to represent them, or the court will appoint somebody. We get asked to represent the alleged incapacitated person just to make sure that everything is above board, so to speak. Once the story is laid out for the judge, then a decision will ultimately be made. You can have somebody petition requesting guardianship for somebody who who does have capacity, and that's when the judge will put a halt to it and say, no, nobody can take away this person's legal rights if they have capacity. So automatically, are you appointed as your spouse or your parent or your child's guardian? No, there is a court process we go through where the judge, who is the ultimate decision maker, will make that decision if it's an appropriate action.
Does every special needs child need a guardian?
The answer to that question is no. Not everybody's the same. So just because there's a diagnosis in place, whether it's autism or Down syndrome or a more medical condition, doesn't mean guardianship is automatic or necessary. I have a whole bunch of clients who are over the age of 18 who fall under this umbrella of special needs, who have capacity and can make a decision and sign powers of attorney without any problem. So automatically, guardianship isn't necessarily required. We'd have to review each individual case separately to see if it's appropriate. If it is appropriate, then typically it's the parents or siblings will go through the guardianship process, requesting the court appoint them as guardian of the person or of the estate. And we will get into more guardianship questions next week. But if you have any other questions, feel free to leave them in the comments and we'll answer them soon.